Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. అందరికీ శుభోదయం. This is a motor vehicle accident case. Not motor vehicle, but a fatal accident during work hours. Or simply to say, when a fatal accident takes place, when a person is on the way to his workplace, that is work commute, whether compensation has to be paid or not. In simple terms, a watchman, security guard, తన డ్యూటీకి వెళ్ళటానికి టైం అయిపోతుంది, ఇంటి దగ్గర నుంచి మోటార్ సైకిల్ మీద వెళ్తుంటాడు, యాక్సిడెంట్ అవుతుంది, చనిపోతాడు. కెన్ ఇట్ బి టేకెన్ యాజ్ వర్క్ కమ్యూట్ ఆర్ నాట్? హైకోర్టే కాదండి, కానీ సుప్రీంకోర్టు ఎస్ అంది. అది మీకు చెప్తున్నాను. సో దిస్ ఈజ్ ఎ కేస్ ఆఫ్ ఎంప్లాయీస్ కాంపెన్సేషన్ యాక్ట్ 1923. Supreme Court judgment. Justice Manoj Mishra and K.V. Vishwanathan in the case of Daivshala, DAIV, Daivshala and others versus Oriental Insurance Company Limited. Civil Appeal number 6986 by 2015. Decided on 29th July 2025. In which it was held that when a watchman was commuting to his workplace at midnight, he has started for his workplace in the midnight, and when he was about 5 kilometers away from the place, he met with an accident. So the nexus, that is employment duty, exists to reasonable circumstances because there are reasonable nexus. He is going there only for performing his work. Kabatti, the interpretation is that the object has to be taken into account. Now coming to the facts of the case. The deceased person or watchman is Sahu Sampatrao Jadhav. ఇది మహారాష్ట్ర స్టేట్లో జరిగింది. The watchman, Mr. Jadhav, he was working in a sugar factory. His duty is from 3 a.m. to 11 a.m. on 22/4/2003. So night kabatti, he left on motorcycle to the sugar factory, but in the meanwhile, so unexpectedly an accident took place wherein he died. He died leaving a large family behind him, wife, 4 children and mother. So his wife, Daivshala and others, they filed a claim petition under Employees Compensation Act 1923. Of course, here the commissioner and subjudge for the employment compensation, he has differed with the argument of the insurance company. Insurance company says it defends that the accident occurred outside the premises. So the accident did not occur inside the premises. Accident ఇతను వర్క్ చేసే చోట అయితే ఓకే, సెక్షన్ 3 ఆఫ్ ది ఎంప్లాయీస్ కాంపెన్సేషన్ యాక్ట్లో సో అరైజింగ్ అవుట్ ఆఫ్ అండ్ అరైజింగ్ out in the course of employment. If any accident arises in the course of employment, yes, he will be given compensation, but it is outside the premises. But civil judge Usmanabad, no, he did not accept, because the work commute is, yes, he is going there for doing work, there is a connection. So he has awarded compensation of 3.26 lakhs something, మిగతా డబ్బులు చాలా వచ్చింది, at the rate of 20% interest from 22/5/2003. Actually, accident జరిగింది 22/4/2003. వీళ్ళు 1 month తర్వాత వేసినట్టున్నారు. ఆ రోజు నుంచి 3.26 lakhs at the rate of 12% interest కూడా ఇచ్చాడు. Then the matter insurance company did not keep quiet. They made a first appeal to the Bombay High Court. So Bombay High Court reversed the judgment of the civil judge, stating that it did not occur within the premises. It did not occur in the course of employment. It is outside the employment అని చెప్పి రివర్స్ చేశారు. So therefore, accident did not arise in the course of employment. So section 3, arising out of and in the course of employment. ఇక్కడ so pari materia, Supreme Court interpretation in the pari materia. Pari materia అంటే of the same kind, of the same sections. అంటే కొన్ని సందర్భాల్లో ఒక యాక్ట్లో ఒక సెక్షన్ ఉంటుంది, ఇంకో యాక్ట్లో ఇంకోటి సెక్షన్. They should be read together. Section 3 of the Employees Compensation Act has to be read with Section 51 of the Employees State Insurance Act. So there it is very clearly stated that so Employees Compensation Section 3 and Employees Insurance Act, ESI Act 51, when they are both read together, since both of them are beneficial legislations with the same phrasing, so compensation should be awarded. Pari materia. So when two acts deal with the same thing, so you can construe both of construction and అదే కదా. ఇంటర్ప్రిటేషన్ అంటే దాని నుంచి తీసుకోవడం, కన్స్ట్రక్షన్ మీన్స్ మీనింగ్ఫుల్ తీసుకోవడం. సో జస్ట్ లైక్ కొన్ని సందర్భాల్లో ఒక ఆస్పెక్ట్ మీదే అవుట్రేజింగ్ ద మోడెస్టీ 354, అలాగే SC/STలో కూడా అవుట్రేజింగ్ మోడెస్టీ ఉంటుంది. అట్లా ఈ రెండు అర్థాలు కలిపి తీసుకోవాలి. రైట్. సో నైట్ వాచ్మెన్ డ్యూటిఫుల్లీ he was proceeding to his workplace from the house. So that means there is a connection or there is a clear nexus between the circumstances. మధ్యలో అయితే ఏదైనా కూరగాయలకి పోతే లేదా తాగడానికి పోతే not so doubt, definitely you can say it is outside the employment. But when he is going there purposefully attend for his duty, it is within the meaning of going towards the duty. So 51 ESI Act is clarificatory in this aspect. So the compensation is admissible. So pari materia రాశారు, it is well settled law that where statutes in pari materia serve a common object, కంపెనీ లా అలాగే ఇన్కమ్ ట్యాక్స్ యాక్ట్ ఇట్లా కూడా ఇలాగే వస్తుంది. సో ఇట్ ఈస్ పర్మిసిబుల్ ఫర్ ఎ కోర్ట్ ఆఫ్ లా టు ascertain. So please remember, by comparison or by framing up the language with the other enactment relating to the same subject matter, the object is beneficial legislation. It is there for the benefit of the deceased persons. We can't expect each and every person die. No doubt, he is a man, able-bodied man, but due to the accident, he lost his life and now the entire family is bewildered. What do they have to do? They have to get compensation, is it not? Therefore, Supreme Court interpreted the matter in pari materia and observed that you have to read the sections together. Section 3 of the Employees Compensation Act together with Section 51 of the Employees State Insurance Act. If you combine both these, read them, definitely you will come to the conclusion that benefits have to accrue to the deceased person. Now he is a loss. So very good case law. Please read it and enrich your legal knowledge. I am stopping here. Thank you very much.